The First Amendment, Amendment I, to the United States Constitution prevents Congress from making any law respecting an establishment of religion, prohibiting the free exercise of religion, or abridging the freedom of speech, the freedom of the press, the right to peaceably assemble, or to petition for a governmental redress of grievances. It was adopted on December 15, 1791, as one of the 10 amendments that constitute the Bill of Rights. The Bill of Rights was originally proposed to assuage anti-federalist opposition to constitutional ratification. Initially, the First Amendment applied only to laws enacted by the Congress, and many of its provisions were interpreted more narrowly than they are today. Beginning with Gitlow v. New York, 1925, the Supreme Court applied the First Amendment to states, a process known as incorporation through the Due Process Clause of the 14th Amendment. In Everson v. Board of Education, 1947, the court drew on Thomas Jefferson's correspondence to call for a wall of separation between church and state, though the precise boundary of this separation remains in dispute. Speech rights were expanded significantly in a series of 20th and 21st century court decisions which protected various forms of political speech, anonymous speech, campaign financing, pornography, and school speech. These rulings also defined a series of exceptions to First Amendment protections. The Supreme Court overturned English common law precedent to increase the burden of proof for defamation and libel suits, most notably in New York Times Co. v. Sullivan, 1964. Commercial speech, however, is less protected by the First Amendment than political speech, and is therefore subject to greater regulation. The Free Press Clause protects publication of information and opinions, and applies to a wide variety of media. In Neer v. Minnesota, 1931, and New York Times v. United States, 1971, the Supreme Court ruled that the First Amendment protected against prior restrained pre-publication censorship in almost all cases. The Petition Clause protects the right to petition all branches and agencies of government for action. In addition to the right of assembly guaranteed by this clause, the court has also ruled that the amendment implicitly protects freedom of association. Text. The amendment as adopted in 1791 reads as follows. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble, and to petition the government for a redress of grievances. Background. In 1776, the second year of the American Revolutionary War, the Virginia colonial legislature passed a Declaration of Rights that included the sentence, "The freedom of the press is one of the greatest bulwarks of liberty, and can never be restrained but by despotic governments." 8 of the other 12 states made similar pledges. However, these declarations were generally considered mere admonitions to state legislatures, rather than enforceable provisions. After several years of comparatively weak government under the Articles of Confederation, a constitutional convention in Philadelphia proposed a new constitution on September 17, 1787, featuring among other changes a stronger chief executive. George Mason, a constitutional convention delegate and the drafter of Virginia's Declaration of Rights, proposed that the Constitution include a Bill of Rights listing and guaranteeing civil liberties. Other delegates, including future Bill of Rights drafter James Madison, disagreed, arguing that existing state guarantees of civil liberties were sufficient and that any attempt to enumerate individual rights risked the implication that other, unnamed rights were unprotected. After a brief debate, Mason's proposal was defeated by a unanimous vote of the state delegations. For the Constitution to be ratified, however, 9 of the 13 states were required to approve it in state conventions. Opposition to ratification, anti-federalism, was partly based on the Constitution's lack of adequate guarantees for civil liberties. Supporters of the Constitution in states where popular sentiment was against ratification, including Virginia, Massachusetts, and New York, successfully proposed that their state conventions both ratify the Constitution and call for the addition of a Bill of Rights. The U.S. Constitution was eventually ratified by all 13 states. In the first United States Congress, following the state legislature's request, James Madison proposed 20 constitutional amendments, and his proposed draft of the First Amendment read as follows. The civil rights of none shall be abridged on account of religious belief or worship, nor shall any national religion be established, nor shall the full and equal rights of conscience be in any manner, or on any pretext, infringed. The people shall not be deprived or abridged of their right to speak, to write, or to publish their sentiments, and the freedom of the press, as one of the great bulwarks of liberty, shall be inviolable. The people shall not be restrained from peaceably assembling and consulting for their common good, nor from applying to the legislature by petitions, or remonstrances, for redress of their grievances. This language was greatly condensed by Congress, and passed the House and Senate with almost no recorded debate, complicating future discussion of the amendment's intent. The First Amendment, along with the rest of the Bill of Rights, was submitted to the states for ratification on September 25, 1789, and adopted on December 15, 1791. Establishment of religion. Thomas Jefferson wrote with respect to the First Amendment and its restriction on the legislative branch of the federal government in an 1802 letter to the Danbury Baptists, a religious minority concerned about the dominant position of the Congregational Church in Connecticut. Believing with you that religion is a matter which lies solely between man and his God, that he owes account to none other for his faith or his worship, that the legitimate powers of government reach actions only, and not opinions, I contemplate with sovereign reverence that act of the whole American people which declared that their legislature should make no law respecting an establishment of religion, or prohibiting the free exercise thereof, thus building a wall of separation between church and state. Adhering to this expression of the supreme will of the nation in behalf of the rights of conscience, I shall see with sincere satisfaction the progress of those sentiments which tend to restore to man all his natural rights, convinced he has no natural right in opposition to his social duties. In Reynolds v. United States, 1878, the Supreme Court used these words to declare that it may be accepted almost as an authoritative declaration of the scope and effect of the amendment thus secured. Congress was deprived of all legislative power over mere opinion, but was left free to reach actions which were in violation of social duties or subversive of good order. Quoting from Jefferson's Virginia Statute for Religious Freedom, the court stated further in Reynolds. In the preamble of this act religious freedom is defined, and after a recital that to suffer the civil magistrate to intrude his powers into the field of opinion, and to restrain the profession or propagation of principles on supposition of their ill tendency, is a dangerous fallacy which at once destroys all religious liberty. It is declared that it is time enough for the rightful purposes of civil government for its officers to interfere when principles break out into overt acts against peace and good order. In these two sentences is found the true distinction between what properly belongs to the Church and what to the state. Originally, the First Amendment applied only to the federal government, and some states continued official state religions after ratification. Massachusetts, for example, was officially congregational until the 1830s. In Everson v. Board of Education, 1947, the U.S. Supreme Court incorporated the Establishment Clause, i.e., made it apply against the states. The Establishment of Religion Clause of the First Amendment means at least this: neither a state nor the federal government can set up a church. Neither can pass laws which aid one religion, aid all religions, or prefer one religion to another. In the words of Jefferson, the clause against establishment of religion by law was intended to erect a wall of separation between church and state. That wall must be kept high and impregnable. We could not approve the slightest breach. In Torquezo v. Watkins, 1961, the Supreme Court ruled that the Constitution prohibits states and the federal government from requiring any kind of religious test for public office. In the Board of Education of Kiryas Joel Village School District v. Grumit, 1994, the court concluded that government should not prefer one religion to another, or religion to irreligion. In a series of cases in the first decade of the 2000s, Van Orden v. Perry, 2005, McCreary County v. ACLU, 2005, and Salazar v. Buono, 2010, the court considered the issue of religious monuments on federal lands without reaching a majority reasoning on the subject. Separationists. Everson used the metaphor of a wall of separation between church and state, derived from the correspondence of President Thomas Jefferson. It had been long established in the decisions of the Supreme Court, beginning with Reynolds v. United States in 1879, when the court reviewed the history of the early republic in deciding the extent of the liberties of Mormons. Chief Justice Morrison Waite, who consulted the historian George Bancroft, also discussed at some length the memorial and remonstrance against religious assessments by James Madison, who drafted the First Amendment. Madison used the metaphor of a great barrier. In Everson, the court adopted Jefferson's words. The court has affirmed it often, with majority, but not unanimous, support. Warren Nord, in Does God Make a Difference?, characterized the general tendency of the dissents as a weaker reading of the First Amendment. The dissents tend to be less concerned about the dangers of establishment and less concerned to protect free exercise rights, particularly of religious minorities. Beginning with Everson, which permitted New Jersey school boards to pay for transportation to parochial schools, the court has used various tests to determine when the wall of separation has been breached. Everson laid down the test that establishment existed when aid was given to religion, but that the transportation was justifiable because the benefit to the children was more important. In the school prayer cases of the early 1960s, Engel v. Vital and Abington School District v. Skemp, aid seemed irrelevant. The court ruled on the basis that a legitimate action both served a secular purpose and did not primarily assist religion. In Walls v. Tax Commission, 1970, the court ruled that a legitimate action could not entangle government with religion. In Lemon v. Kurtzman, 1971, these points were combined into the Lemon test, declaring that an action was an establishment if the statute, or practice, lacked a secular purpose. Its principal or primary effect advanced or inhibited religion, or it fostered an excessive government entanglement with religion. The Lemon test has been criticized by justices and legal scholars, but it remains the predominant means by which the court enforces the Establishment Clause. In Agostini v. Felton, 1997, the entanglement prong of the Lemon test was demoted to simply being a factor in determining the effect of the challenged statute or practice. In Zellman v. Simmons Harris, 2002, the opinion of the court considered secular purpose and the absence of primary effect. A concurring opinion saw both cases as having treated entanglement as part of the primary purpose test. Further tests, such as the endorsement test and coercion test, have been developed to determine whether a government action violated the Establishment Clause. In Lemon, the court stated that the separation of church and state could never be absolute. Our prior holdings do not call for total separation between church and state. Total separation is not possible in an absolute sense. Some relationship between government and religious organizations is inevitable, the court wrote. Judicial caveats against entanglement must recognize that the line of separation, far from being a wall, is a blurred, indistinct, and variable barrier depending on all the circumstances of a particular relationship. Accommodationists. Accommodationists, in contrast, argue along with Justice William O. Douglas that are a religious people whose institutions presuppose a supreme being. This group holds that the Lemon test should be applied selectively. As such, for many conservatives, the Establishment Clause solely prevents the establishment of a state church, not public acknowledgments of God nor developing policies that encourage general religious beliefs that do not favor a particular sect and are consistent with the secular government's goals. Free exercise of religion. Freedom of religion means freedom to hold an opinion or belief, but not to take action in violation of social duties or subversive to good order. In Reynolds v. United States, 1878, the Supreme Court found that while laws cannot interfere with religious belief and opinions, laws can be made to regulate some religious practices, e.g., human sacrifices, and the Hindu practice of sati. The court stated that to rule otherwise, would be to make the professed doctrines of religious belief superior to the law of the land, and in effect permit every citizen to become a law unto himself. Government would exist only in name under such circumstances. In Cantwell v. Connecticut, 1940, the court held that the Due Process Clause of the 14th Amendment applied the Free Exercise Clause to the states. While the right to have religious beliefs is absolute, the freedom to act on such beliefs is not absolute. In Sherbert v. Verner, 1963, the Supreme Court required states to meet the strict scrutiny standard when refusing to accommodate religiously motivated conduct. This meant that a government needed to have a compelling interest regarding such a refusal. The case involved Adele Sherbert, who was denied unemployment benefits by South Carolina because she refused to work on Saturdays, something forbidden by her Seventh-day Adventist faith. In Wisconsin v. Yoder, 1972, the court ruled that a law that unduly burdens the practice of religion without a compelling interest, even though it might be neutral on its face, would be unconstitutional. The need for a compelling governmental interest was narrowed in Employment Division v. Smith, 1990, which held no such interest was required under the Free Exercise Clause regarding a neutral law of general applicability that happens to affect a religious practice, as opposed to a law that targets a particular religious practice, which does require a compelling governmental interest. In Church of Lukumai Babalu IV City of Hialeah, 1993, the Supreme Court ruled Hialeah had passed an ordinance banning ritual slaughter, a practice central to the Santeria religion, while providing exceptions for some practices such as the kosher slaughter. Since the ordinance was not generally applicable, the court ruled that it needed to have a compelling interest, which it failed to have, and so was declared unconstitutional. In 1993, the Congress passed the Religious Freedom Restoration Act, Rfra, seeking to restore the compelling interest requirement applied in Sherbert and Yoder. In City of Bruni v. Flores, 1997, the court struck down the provisions of Rfra that force state and local governments to provide protections exceeding those required by the First Amendment, on the grounds that while the Congress could enforce the Supreme Court's interpretation of a constitutional right, the Congress could not impose its own interpretation on states and localities. According to the court's ruling in Gonzales v. UDV, 2006, Rfra remains applicable to federal laws, and so those laws must still have a compelling interest. Freedom of speech and of the press. Wording of the clause. The First Amendment bars Congress from abridging the freedom of speech, or of the press. U.S. Supreme Court Justice John Paul Stevens commented about this phraseology in a 1993 journal article. I emphasize the word "the" in the term "the freedom of speech" because the definite article suggests that the draftsman intended to immunize a previously identified category or subset of speech. Stevens said that, otherwise, the clause might absurdly immunize things like false testimony under oath. Like Stevens, journalist Anthony Lewis wrote, the word "the" can be read to mean what was understood at the time to be included in the concept of free speech. But what was understood at the time is not 100% clear. In the late 1790s, the lead author of the Speech and Press Clauses, James Madison, argued against narrowing this freedom to what had existed under English common law. The practice in America must be entitled to much more respect. In every state, probably, in the Union, the press has exerted a freedom in canvassing the merits and measures of public men, of every description, which has not been confined to the strict limits of the common law. Madison wrote this in 1799, when he was in a dispute about the constitutionality of the Alien and Sedition laws, which was legislation enacted in 1798 by President John Adams' Federalist Party to ban seditious libel. Madison believed that legislation to be unconstitutional, and his adversaries in that dispute, such as John Marshall, advocated the narrow freedom of speech that had existed in the English common law. Speech critical of the government. The Supreme Court declined to rule on the constitutionality of any federal law regarding the Free Speech Clause until the 20th century. For example, the Supreme Court never ruled on the Alien and Sedition Acts. 3 Supreme Court justices riding circuit presided over sedition trials without indicating any reservations. The leading critics of the law, Vice President Thomas Jefferson and James Madison, argued for the Act's unconstitutionality based on the First Amendment and other constitutional provisions. Jefferson succeeded Adams as president, in part due to the unpopularity of the latter's sedition prosecutions. He and his party quickly overturned the acts and pardoned those imprisoned by them. In the majority opinion in New York Times Co. v. Sullivan, 1964, the court noted the importance of this public debate as a precedent in First Amendment law and ruled that the acts had been unconstitutional. Although the Sedition Act was never tested in this court, the attack upon its validity has carried the day in the court of history. World War I. During the patriotic fervor of World War I and the First Red Scare, the Espionage Act of 1917 imposed a maximum sentence of 20 years for anyone who caused or attempted to cause insubordination, disloyalty, mutiny, or refusal of duty in the military or naval forces of the United States. Specifically, the Espionage Act of 1917 states that if anyone allows any enemies to enter or fly over the United States and obtain information from a place connected with the national defense, they will be punished. Hundreds of prosecutions followed. In 1919, the Supreme Court heard 4 appeals resulting from these cases: Schenck v. United States, Debs v. United States, Rfra v. United States, and Abrams v. United States. In the first of these cases, Socialist Party of America official Charles Schenck had been convicted under the Espionage Act for publishing leaflets urging resistance to the draft. Schenck appealed, arguing that the Espionage Act violated the Free Speech Clause of the First Amendment. In Schenck v. United States, the Supreme Court unanimously rejected Schenck's appeal and affirmed his conviction. This conviction continued to be debated over whether Schenck went against the right to freedom of speech protected by the First Amendment. Justice Oliver Wendell Holmes, Jr., writing for the court, explained that the question in every case is whether the words used are used in such circumstances and are of such a nature as to create a clear and present danger that they will bring about the substantive evils that Congress has a right to prevent. 1 week later, in Rfra v. United States, the court again upheld an Espionage Act conviction, this time that of a journalist who had criticized U.S. involvement in foreign wars. In Debs v. United States, the court elaborated on the clear and present danger test established in Schenck. On June 16, 1918, Eugene V. Debs, a political activist, delivered a speech in Canton, Ohio, in which he spoke of most loyal comrades were paying the penalty to the working class, these being Wagenknecht, Baker, and Ruthenberg, who had been convicted of aiding and abetting another in failing to register for the draft. Following his speech, Debs was charged and convicted under the Espionage Act. In upholding his conviction, the court reasoned that although he had not spoken any words that posed a clear and present danger, taken in context, the speech had a natural tendency and a probable effect to obstruct the recruiting services. In Abrams v. United States, 4 Russian refugees appealed their conviction for throwing leaflets from a building in New York. The leaflets argued against President Woodrow Wilson's intervention in Russia against the October Revolution. The majority upheld their conviction, but Holmes and Justice Louis Brandeis dissented, holding that the government had demonstrated no clear and present danger in the 4's political advocacy. Extending protections. The Supreme Court denied a number of free speech clause claims throughout the 1920s, including the appeal of a labor organizer, Benjamin Gitlow, who had been convicted after distributing a manifesto calling for a revolutionary dictatorship of the proletariat. In Gitlow v. New York, 1925, the court upheld the conviction, but a majority also found that the First Amendment applied to state laws as well as federal laws, via the Due Process Clause of the 14th Amendment. Holmes and Brandeis dissented in several more cases in this decade, however, advancing the argument that the Free Speech Clause protected a far greater range of political speech than the court had previously acknowledged. In Whitney v. California, 1927, in which Communist Party USA organizer Charlotte Anita Whitney had been arrested for criminal syndicalism, Brandeis wrote a dissent in which he argued for broader protections for political speech. Those who won our independence believed that freedom to think as you will and to speak as you think are means indispensable to the discovery and spread of political truth, that without free speech and assembly discussion would be futile, that with them, discussion affords ordinarily adequate protection against the dissemination of noxious doctrine, that the greatest menace to freedom is an inert people, that public discussion is a political duty, and that this should be a fundamental principle of the American government. In Herndon v. Lowry, 1937, the court heard the case of African American Communist Party organizer Angelo Herndon, who had been convicted under the slave insurrection statute for advocating black rule in the southern United States. In a 5-4 decision, the court reversed Herndon's conviction, holding that Georgia had failed to demonstrate that there was any clear and present danger in Herndon's political advocacy. In 1940, Congress enacted the Smith Act, making it illegal to advocate the propriety of overthrowing or destroying any government in the United States by force and violence. The statute provided law enforcement a tool to combat communist leaders. Eugene Dennis was convicted in the Foley Square trial for attempting to organize a communist party. In Dennis v. United States, 1951, the court upheld the law, 6-2. Chief Justice Fred M. Vinson relied on Holmes' clear and present danger test as adapted by learned hand, in each case must ask whether the gravity of the evil, discounted by its improbability, justifies such invasion of free speech as necessary to avoid the danger. Clearly, Vinson suggested, clear and present danger did not intimate that before the government may act, it must wait until the putsch is about to be executed, the plans have been laid and the signal is awaited. In a concurring opinion, Justice Felix Frankfurter proposed a balancing test, which soon supplanted the clear and present danger test. The demands of free speech in a democratic society as well as the interest in national security are better served by candid and informed weighing of the competing interests, within the confines of the judicial process. In Yates v. United States, 1957, the Supreme Court limited the Smith Act prosecutions to advocacy of action rather than advocacy in the realm of ideas. Advocacy of abstract doctrine remained protected while speech explicitly inciting the forcible overthrow of the government was punishable under the Smith Act. During the Vietnam War, the court's position on public criticism of the government changed drastically. Though the court upheld a law prohibiting the forgery, mutilation, or destruction of draft cards in United States v. O'Brien, 1968, fearing that burning draft cards would interfere with the smooth and efficient functioning of the draft system, the next year, the court handed down its decision in Brandenburg v. Ohio, 1969, expressly overruling Whitney v. California. Now the Supreme Court referred to the right to speak openly of violent action and revolution in broad terms. Decisions have fashioned the principle that the constitutional guarantees of free speech and free press do not allow a state to forbid or proscribe advocacy of the use of force or law violation except where such advocacy is directed to inciting or producing imminent lawless action and is likely to incite or cause such action. Brandenburg discarded the clear and present danger test introduced in Schenck and further eroded Dennis. In Cohen v. California, 1971, the court voted 5-4 to reverse the conviction of a man wearing a jacket reading "Fuck the draft" in the corridors of a Los Angeles County courthouse. Justice John Marshall Harlan II wrote in the majority opinion that Cohen's jacket fell in the category of protected political speech despite the use of an expletive. One man's vulgarity is another man's lyric. Political speech. Anonymous speech. In Talley v. California, 1960, the court struck down a Los Angeles city ordinance that made it a crime to distribute anonymous pamphlets. Justice Hugo Black wrote in the majority opinion, "There can be no doubt that such an identification requirement would tend to restrict freedom to distribute information and thereby freedom of expression." Anonymous pamphlets, leaflets, brochures, and even books have played an important role in the progress of mankind. In McIntyre v. Ohio Elections Commission, 1995, the court struck down an Ohio statute that made it a crime to distribute anonymous campaign literature. However, in Meese v. Keene, 1987, the court upheld the Foreign Agents Registration Act of 1938, under which several Canadian films were defined as political propaganda, requiring their sponsors to be identified. Campaign finance. In Buckley v. Valeo, 1976, the Supreme Court reviewed the Federal Election Campaign Act of 1971 and related laws, which restricted the monetary contributions that may be made to political campaigns and expenditure by candidates. The court affirmed the constitutionality of limits on campaign contributions, stating that they serve the basic governmental interest in safeguarding the integrity of the electoral process without directly impinging upon the rights of individual citizens and candidates to engage in political debate and discussion. However, the court overturned the spending limits, which it found imposed substantial restraints on the quantity of political speech. The court again scrutinized campaign finance regulation in McConnell v. Federal Election Commission, 2003. The case centered on the Bipartisan Campaign Reform Act of 2002, BCRA, a federal law that imposed new restrictions on campaign financing. The Supreme Court upheld provisions which barred the raising of soft money by national parties and the use of soft money by private organizations to fund certain advertisements related to elections. However, the court struck down the choice of expenditure rule, which required that parties could either make coordinated expenditures for all its candidates, or permit candidates to spend independently, but not both, which the court agreed placed an unconstitutional burden on the party's right to make unlimited independent expenditures. The court also ruled that the provision preventing minors from making political contributions was unconstitutional, relying on Tinker v. Des Moines Independent Community School District. In Federal Election Commission v. Wisconsin Right to Life Incorporated, 2007, the court sustained an as-applied challenge to BCRA, holding that issue ads may not be banned from the months preceding a primary or general election.
Please subscribe and thanks for watching.